Everybody waiting too long? Scott, do you want
All right.
to go ahead?
Good afternoon, everyone, and thank you again for joining us for this third talk in our series over the past Thursdays with Margaret Barrett of Safe Harbor Estate Law and Planning. We've gotten bits and pieces and nuggets as we've gone along on this journey, and Margaret has been gracious in offering us complimentary consultation. So I hope that you take advantage of that in terms of with your specific individualized questions that she may not be able to answer very individually to you today as we go through this presentation. I'm Scott, and I am from the Glenn Hopkins Senior Living community. We are a housing with services community, and we provide housing and services for seniors 62 years of age or better. We provide independent living plus, where you can add on some household support services or some scheduled home care services from our own on-site home care called Gentle Touch Health Initiatives. We also are that continuum of care, so we provide assisted living services where there's that caregiving staff 24/7, as well as our specialized memory care neighborhoods to provide private apartment homes, as well as specialized home care services and social engagement with our community life staff for those dealing with and living with memory loss. The Glenn Hopkins, as I mentioned, is located right here in the southwest corner of Hopkins. We sit on 14 acres of green space with walking paths, resident gardens, and a protected wetland called Willow Pond in our backyard. We are very fortunate to also have a very dedicated pastoral care staff that provides spiritual support and different activities for individuals that live here at our community, as well as staff and families. They do that through a variety of different things with scheduled chapel services, both the daily Catholic Mass as well as interfaith services during the course of the week for all faith traditions that live at our community, as well as small group and individual counseling as we journey through those different changes that happen as we age, whether they're financial or the loss of a loved one within our families. I also like to highlight on our independent living side, we are very fortunate to have a licensed social worker that supports our seniors and families as they go through different changes. Again, both financial health changes and sometimes emotional changes with different kinds of losses and gains at this different stage of retirement and aging. But she's available in providing resources such as the resources of Margaret's estate law firm in helping families and residents as they're journeying through this different stage of later retirement years. You can always find more information about the Glenn Hopkins by visiting our website at www.theglenhopkins.com, and you can catch up on what we've been doing on a day-to-day basis and weekly basis by visiting our Facebook page at facebook.com/theglenhopkins. Always great pictures and updates that tells the story of what we've been up to as a community on a daily basis and as we kind of navigate and journey through this winter season. Thank you again for being here with us this afternoon. And at this time, I'm going to turn it over to Margaret. As she mentioned, we're going to journey through what seniors should know about income tax, guardianship, and working in blended families. Thank you.
Thank you so much for hosting us, Scott. And I really like that introduction because my mom's in a senior living facility, and I liked what you said about the counseling, the social worker, the spiritual support, and that nature area. So I know that your interior design looks beautiful, so I look forward to visiting there when we can do that safely for everybody. As Scott said, today I'm going to talk to you about our smooth sailing system for guardianship and conservatorship. That's one. I'm also going to talk about special concerns for blended families and special concerns for taxes for seniors. Of course, we're not covering everything. I want to give you a basic understanding so you can spot red flags and know when you should call for help or maybe recommend a friend. A lot of times with elder law, I find that people don't know there's resources there and they're struggling with a lot of overwhelming situations. And so getting educated can help you and your loved ones, but also your friends. Seen that happen many times. And so, and we'll also offer you the free resources, including a handout, again, that we think could be helpful for you, and a strategy session if there's further questions or concerns that you think we may be able to help you with. So again, some of this will be repeat for those who were here last week. Our mission is to help you protect what matters most, and we recognize that's the whole family. And so we'll be talking about that today specifically as relates to guardianship, which you want to avoid if you can, blended families, which are great but have special complications, and taxes, which everybody wants to reduce. So those are our goals. Again, my experience
I can't hear you.
Thank you. So it muted me itself. Sorry about that. Okay, so I can relate to my clients because, as I mentioned last time, my siblings and I have supported my dad through his dementia and passing, and now my mom, and given her all the support we can from a distance mostly. Personally, and my family, my first husband died in a car accident. We were divorced, but we had 2 kids together. 7 years of litigation we went through. I'm very motivated to help your family avoid that. Also, I'm in a blended family now with my husband, and I understand from personally and also from a lot of clients that I've worked with how we can help with those kind of things. I actually have an accounting degree, which I don't usually talk about. So I'm not a tax expert, but I have a good understanding of tax that is needed to be an elder law attorney. So I want you to sleep better at night, knowing that you've done all you can to protect yourself and your loved ones, avoid hassle, and make your hard-earned money go as far as possible. So let's keep going. Again, my credentials, I founded the firm 7 years ago, and I have good experience, good ratings, and I'm involved in the elder bar. So I want to keep up on things. And again, I frequently present if you have any other ideas of where people might be interested in learning this information, because we really want to spread the word and help people know what they need to know to make their lives go smoother. So here's a roadmap of today's talk. First is guardianship conservatorship overview. Second will be complications that can arise with blended family, and third will be taxes for seniors, tax considerations, and then we'll tell you about at the end, how to sign up for our strategy session it is today. So what's exciting is I'm so glad you guys are here, most of you again, and that you're getting educated and empowered to protect what's most important to you, and you'll probably get ahead of most people just by being at one talk even. So I'm just wondering if you have been involved in the appointment of a guardianship or conservator, please put this in the chat. I guess you could speak up if you can't put it in the chat. Most people have not. If you have a good power of attorney and healthcare directive, often the whole guardianship conservator process can be avoided. So we hope to avoid it, but let's learn about what happens when it's needed. What is a guardian and conservator? So a guardian is appointed by the court to protect a person, and the person is called the ward. And so the guardian makes healthcare decisions, kind of like the person in the healthcare directive would, and they decide where the person lives, anything not financial or legal things, but things involving the person. Those are the decisions that they make. So the guardian is similar to having a healthcare directive, kind of, but a healthcare agent that you've appointed in your healthcare directive. That's why often if you have a good healthcare directive and it's working and the person is acting in your best interest, you don't need a guardian. So next, is the conservator. So the conservator handles your finances. Similarly, they're appointed by the court. They're going to handle your finances and the legal. And in this case, the person's called the protected person, not the same name. So the same person could be a ward and a protected person if you need both. But they are separate, financial, legal versus kind of health and personal. So examples of what a conservator does is like pay the bills, change a beneficiary designation, sign contracts, applies for Medicaid, files reports. I had one where we had a conservator appointed to do a divorce. So they can handle financial and legal matters. They can do lawsuits, anything like that. So this, having a conservator, is kind of similar to someone you would appoint in your power of attorney. So if you have a good power of attorney and that person is acting in your best interest, you probably won't need a conservator. So that's kind of how it works. You can kind of think of it as the guardian is sort of like a complex substitute for a healthcare directive, and a conservator is a complex substitute for power of attorney. So that's kind of the basics. Now, what's the goal? The goal of both is always to protect the vulnerable person in the least restrictive way. The courts want people to keep as much freedom, as much control, as much independence and self-direction as possible. But sometimes people need protection. And so that is the purpose of both of these roles. So who needs a guardian or conservator, and what problems do they solve? I'm going to give you a few examples of cases that we've worked on. I think that's kind of the best way, is to hear it in stories. So here's my mom and dad, because, you know, I like to put in a picture of them. And this isn't about them, but another client, Sandy, and her and her husband, they had planned ahead on their estate plan, and he had Lewy body dementia. And then he had this sudden downturn because of another illness that affected his capacity. And so they contacted us, and I went and met with them, and I tried real hard to see if he had capacity to sign the paperwork, the healthcare directive and power of attorney, but he really didn't. So we had to go to court and get the wife appointed as conservator and guardian, even though, you know, a lot of their things were joint. Of course, not the retirement account, you know, things that can't be joint. But she couldn't sign the paperwork to admit him into this facility. And so that's why we went to court and we got appointed. This was, I think, a year or two ago. In December, we got appointed, and he passed away about a month later, which was really sad because it was kind of expensive, you know, a few $1,000s to get the appointment, and then we still had to put in reports and go back to court and get her discharged. But it went smoothly, and the client handled it very well. And so, but it was, you know, they would have rather avoided it for sure. Okay, next example I want to give you. So that was like not having an estate plan in place ahead of time. The next one, this woman, Elsie, she had, I'm using pretend names, you know, she had an estate plan. She had a trust, she had a power of attorney, and she had a healthcare directive, and they were all fine. And she had 3 kids, one out of state, who was my client, because she was very concerned that her mom was not getting the care she needed. She was left alone all week long in her home, and the son would come on the weekends, and there were just a number of concerns. And the son hadn't talked to my client in years, she didn't know why. So that made it harder, and we tried to resolve things. We ended up needing to bring a guardianship. We got one appointed, and it ended up turning out well, despite the stress. Because, first of all, she got good care. She ultimately moved to a facility, and since her care was so much better, she was getting better hydration and nutrition and stuff, she greatly improved in her capacity, and she was much happier. And so that was a huge win, because at one point she had fainted. Her neighbor found her in the front yard in July. It was about 90, and she fainted, and, you know, I was really concerned if she was even going to survive this whole thing. So she's not just surviving, she's prospering. My client and her brother are talking, and they ended up working together, and this guardianship was emergency, and then the family worked it out. So at the end of the emergency, which was like just about 2 months, then that person was discharged and the family worked together. So it's too bad it had to happen, but it ended up being best in the long run, and it protected her. Another example, this is another one where the client, there wasn't paperwork in place. They didn't do their estate planning, and if they would have, it would have been a lot better. But this woman was 59. She fell down the stairs and got a brain injury, would be in the nursing home the rest of her life. I mean, this could easily be 30 years, 20 years. And so her and her husband were separated 4 years, and he was my client. And he came and said, you know, we didn't do the divorce because I was letting her be on my health insurance and just to help her out. But now that this happened, my entire retirement is going to pay for her care, and I will have nothing left. And he was near retirement age. And so understandably, he wanted her to keep getting the help. He was being very attentive to her. But legally, things were not in a row. And so we had to go to court and get a guardian and conservator appointed. And this is the one where we actually got the conservator appointed a professional instead of him, so that the professional could do the divorce. And so she got on government programs and worked everything out in the long run. It was really stressful though, because he was already dealing with visiting her every day and figuring out care and all that kind of stuff. So that was another example, and this was key because we wanted to protect his assets and hers and get her on medical assistance too. And so the guardianship was able to help with that. The fourth example would be this was a young woman. She was 30 years old, visiting her dad in Colorado, and she died. It was really strange. And so we worked with her, but before she died, she was in the hospital, and this was about a 2-week period. So he was scrambling to find out like what were her bills, you know, getting access to things, and was starting a guardianship because he couldn't pay any bills or take care of anything, didn't have any authority. But that she died before the actual guardianship happened. But had she lived, which is what was expected, we wouldn't have had to get a guardianship. So even young people, it's good to have a power of attorney and healthcare directive to avoid guardianship. So these are some red flags that you could watch for where you might need a guardianship. And if you can instead get a power of attorney or work things out with the person handling the power of attorney, it could be avoided. But we should at least look at these issues if the client can't handle their affairs. You know, the person isn't able to handle the checkbook, their finances, paperwork, etc. If you need access to money and you don't have the authority to access it. If you need an application or contract signed, so somebody's moving in the Glen and they don't have the capacity, does somebody have power of attorney to sign? If not, might need to get the conservatorship. Another example is the one I told you about, the elderly lady where the family wasn't acting in her best interest, Elsie. You might have the right paperwork, but if it's not in their best interest, or somebody thinks it's not in their best interest, there can be differences of opinion, then it takes some checking into. Or sometimes someone's appointed already, guardian conservator, and they want to step down, or they need help, or sometimes the guardian conservator hires us for help too. Sometimes the documents need correction. Yeah, it could be a power of attorney, healthcare directive. It could be the guardianship itself. Something changed. Those are issues where a guardian or conservator can change documents. A conservator can. Also, a classic case is if you have a special needs child who's not going to be able to handle all of their affairs as an adult, you may need to get a guardianship when they turn 18. So those are just all situations that might apply. Just to get an idea, here's our smooth sailing guardianship system. So phase 1, you meet with us, we learn about you, you learn about us, and you decide to hire us and give us the information we need. 2 is we basically draft a petition you sign saying these are the facts why this person needs someone appointed. And we send that into the court, we file it. and get a hearing, and we have the hearing, and there's testimony. What a lot of times it's Zoom now, but sometimes with guardianships, they want to see the person in person. And often the person needs to come to court unless their doctor says they're unable to. So that can be a little traumatic. And so after the hearing, we get the order signed, the person's appointed. Sometimes there's a mediation and people agree a settlement without going to court. But either way, you figure out who it's going to be going forward. And then we get the letters, it's called, appointing the person, and we help the guardian conservator figure out how they fulfill their role going forward, because there's rules about that and reports that need to be filed. You can see it's a lot easier to have a power of attorney. So court's always involved. I do recommend that you hire a lawyer, even if the person, well, I'll talk more about that later. There's lower cost lawyers available if the person is indigent. We have to make sure the legal standard is met. We are not going to bring a guardianship if we don't think it's going to win. It may be initiated by the care facility. Sometimes there's no family, and there's a guardian conservator needed, and the care facility can bring an action to have one appointed by the court. So if the person doesn't have anybody, there is a procedure for the system stepping in and taking care of vulnerable people, even if they don't have family or friends involved. So this is the big question that I ask people when they call. Often we'll get a call, I need a guardianship for my brother, or whatever. And so what we need to do is work with them and make sure that no less restrictive measures are available. That's the law. And we have to prove it to the court. And they're going to want to know, what less restrictive measures did you try, and why didn't they work? So first of all, do you have a power of attorney healthcare directive? If you don't, okay, we understand. If you do, why isn't it working? You can put a rep payee, that's for Social Security, or have someone joined on a checking account, even if they don't have power of attorney. It's not the best way to do it, but you can finagle some things that way. You can have the person live in assisted living or have care coming into the house. If someone's watching over them, maybe they'll be okay, and they don't actually need to have someone appointed by the court. Technology. There's more and more available with technology that can help people communicate their wishes and all kinds of things. So pill boxes that are smart, that open up so you take your pills at the right time and the alarm goes off if you don't. And there's all kinds of technology that might help. And these are and supported decision making, which is a whole nother topic. But the idea is that if the person isn't making the best decisions, maybe someone can support them in decision making instead of taking over the decision for them. Kind of like how you might do with your teenage kid. You know, you want them to start getting independence, so you support them in decision making, but you don't just make it for them. And so it's a little bit like that. You're able to try supporting them and see how that goes. And of course, people are entitled to make decisions that are not always the wisest. None of us always makes wise decisions, and there's a little leeway for that. So there's a little bit of gray area there that we need to work through. Lastly, you can have a special needs trust or an ABLE account, which are for people with special needs, and money can only be spent on specific things. So that way they couldn't spend that money like gambling or something like that. And that is a way to protect money for people. So these are all measures that we will look at and make sure we have a good answer for the court. And if we don't, we'll help you try these other measures and see if they work. The timeline for an emergency hearing, you can do an emergency guardianship. It depends on the county, the timing. Sometimes, within 30 days. Sometimes, a lot of times within 7. You can get it in, and the notice requirements are not as severe, and you have the element of surprise, which is an advantage if you're expecting conflict. So that's appropriate if the person is really in danger if you don't get it appointed soon. Most of them are traditional, which would be probably at least 30 to 45 days out, and then you get appointed usually pretty quickly after that. Details vary by the county, how they handle it, and what the timing is. And like I said, a lot of hearings are virtual during COVID. The cost is always a big issue. I would say from about $4,000 for, kind of a typical, I guess it says $3,000 on my slide. I would, $3,000 probably to get them appointed, but then you have to get them discharged afterwards. So it really depends on the situation, how much work the client does, how much they want us to do, and so forth. And we don't have to travel to court right now. That saves some time. And then I said it can go up to $100,000. That's because if there's a big dispute, really, it in a larger state, especially, it can be very expensive. That is not typical. But probably we've done a few for $20,000, $25,000. Not unusual if there's a difference of opinion among the family. It's often paid by the ward. So the person who brings it, let's say a daughter is bringing it and disagreeing with the brother, and as part of mediation, if they settle it, a lot of times everybody's fees get paid by the senior person or the person who's vulnerable. If I move to petition to be guardian and the court appoints me, I for sure will get my attorney's fees paid. So you can't always count on it, but often it comes out of the estate of the ward. If it seems like the people might have different opinions, but they're all in good faith trying to protect the ward. The factors in costs are the complications and disputes. Disputes is by far the biggest, and the number of hearings. And ISP option for the indigent, that's for informa pauperis, it's Latin. And people who do not have funds can qualify to have the fees waived by the court and to have a court-appointed attorney. And so that is the way to go if the person doesn't have money. And this often happens with 18-year-olds. Not always, but often. So that's it for the guardianships. Here's one client who said that he felt like safe harbor is just what the name says, which I love. A quick phone call made him feel like there was hope, and we got everything taken care of at his grandmother's estate, and he had his questions answered better than any Google search, which is true. This stuff is, you can educate yourself on Google, but I really don't feel like you can get the individualized advice on Google. So this was a wonderful grandson from who took good care of his grandmother. And so now we're going to talk about the second main topic, which is blended families, if you guys are still with me here. And it's hard to keep, okay. With blended families. So if you're in, who should be paying attention to this? You might be thinking, I'm not in a blended family, which I understand. But let's kind of go through a mental checklist of if this might apply to you. So either you might be in a blended family now, maybe, you and your spouse, one of you had kids or both of you when you got married, maybe your spouse has passed away. All of that would be a blended family. You're contemplated marrying into a blended family. That's definitely relevant. Or if you or your spouse may eventually remarry if widowed. So it might happen in the future, even if it's not in your situation now. So I think it's good for people to know this information, that there's extra complications. So our estate planning laws are mostly designed for the married couple that got married young, had their kids together, and then was only married to one spouse. So if you have a different arrangement, which many, many people do now, and people are getting remarried at later ages now, so it's very common, that's when these extra issues come into play. So you'll want to pay attention if you're in any of these situations or think you will be. What could go wrong? That's a great picture. So what could go wrong? Well, what we see, and we get calls on frequently, we just had a call yesterday about a dad who was getting ill and second wife, and his children are concerned about his care decisions. Is he getting the good care? And it's a very common concern. People love you, they care about you very much, and they can have different opinions, and it can get very difficult, especially if there's a spouse who's not their parent. So that happens pretty often. Or your family might not get together for Thanksgiving anymore. Could be while you're here or after you're gone. Also, your spouse could be pressured by your children about how they're spending money. Say you die and you leave money to your spouse, and then your kids feel like, well, he or she is living, at a way higher level than they ever did before, and she's just spending all our inheritance. Not unusual. There's a tension there. Next reason, next thing that could go wrong is your children might not inherit any of your hard-earned money. So this has happened to friends of mine. Let's say, I'm in a blended family, and my husband's older than me. So let's say he dies first, and then I get all the money, and then I just arrange it so that it goes to my kids when I die instead of his. Or I get remarried and it ends up all going to my new husband. It goes to his kids. It doesn't even go to mine. Because you got to remember that people don't always keep up their estate plans. Most people don't. So you kind of got to count on them not doing that, even if they mean well. So a lot of times kids can get shorted in that if you don't have a good plan. Your spouse may not have enough money to live comfortably and get care. That might happen if they're most of your kids, or you just have an arrangement with the house. There can be difficulties about that. Lastly, lots of money could be spent on attorney's fees, and your wishes are still not fulfilled. I mean, it's bad enough if you have to spend money on attorney's fees. You want your wishes fulfilled, but sometimes we can't even reach that goal in the end. So much better to have good planning in place to minimize these problems and prevent surprises. I will tell you about a client I had about 2 years ago. Wonderful guy, Ken, wonderful. Great kids. He was remarried for a number of years. He owned this house on a lake nearby, and his wife kept trying to put him in the nursing home, and he didn't want to go in the nursing home, and I don't really think he was ready for the nursing home, but and so he decided to stay with his daughter. He decided to move in with his daughter, and he was thinking about divorcing his wife when I met him. So he wanted to change who was controlling his money and things like that. And then things just really escalated with one of his sons and his wife's children and her. I mean, the police were called multiple times. It was very messy and expensive. They brought a guardianship action to fight the paperwork he signed with me. There was a number of lawyers involved. I actually had to step back because I was a fact witness and help them find new lawyers. Very complex. What happened in the end, he decided to go back to his wife. So it was really surprising, but he decided to. And so now, though the kids are still split and they spent all this money and they really weren't sure what was right, but it was just a very, very difficult situation. And planning before things got contentious like that would have been better. And who said at the beginning, it's one of our attendees, but I can't see his name right now. He said that he's concerned, you have a good estate plan in order, Jim, and you want to communicate it to the kids. That is a step that could have really helped this family. I also would have liked to look at the estate plan and improved it, but communicating with everybody ahead of time would have been good. So, okay, my next example is, okay, this is Ralph and Sherry. This was a blended family. So, in my office was the wife, Sherry, and her daughter, and the daughter of Ralph. So both sides were very concerned. Ralph was in the nursing home, a very expensive care. Sherry was running out of money. There's just lots of concerns. Ralph's family just said, I just want enough, get him on Medicaid and have enough money for a decent funeral. We didn't know how long Sherry would live. We wanted her to have enough money. We needed to kind of untangle things and get each one's daughters handling their own stuff because the parents weren't as capable anymore. So everybody was worried. We had to update documents. The hardest thing for this family was they were negotiating at a really stressful time. So I could just see how the toll that it took on them, and especially because the money was running out because he was so sick. And so, and then there was issues about his care. So we were able to help them, but it was a difficult time for the family. So here's some possible solutions. If you're not married yet, or if you know somebody who's going to get married and be in a blended family, I highly recommend a prenuptial agreement. It doesn't mean that you're planning on getting divorced. Prenuptial agreements are really important for estate planning. So if you have some really great terms in your estate plan that are just perfect for a blended family, or as good as we can get them, if you also have those terms in a prenuptial agreement, it is much more solid. It is much harder to contest because you thought it through before you were married. Once you're married, the court kind of recognizes, you kind of lost some bargaining power when you got married. And so anything you agree to before marriage is better. And it's actually really healthy to talk these things through. And we can coach people on it and help it be more comfortable so that you can decide ahead of time. So my husband and I did this. Of course we did it. That's what I do. So, I talked to him about some of these options I'm going to talk to you about. And we actually each had our own lawyer because that's the best way to do it. And so we did this because not only do we want to think things through really thoroughly and get advice from other lawyers with, objective perspective, we also want to make it harder to contest. We want our kids to know, no, we really thought this through. We got advice, and so it's great to have a prenuptial agreement. It really is. And it'd be good to contact a lawyer, ideally 3 months before you get married. Certainly not 2 weeks. A month would be the shortest, probably, the very shortest. So secondly, it's really good to have a living trust instead of just a will if you are in a blended family. So some of the options I'm going to talk about, you have to have a trust for. There's other benefits for a blended family, but I'm just going to focus on a few of them. Let's see. Okay. One thought, here's a thought that you can have in your trust. When you die, you might want some money to go to your kids. Say 20% or 10% or something, so they get something right when you pass. And then maybe a lot of times people have the rest for their spouse while they're alive. If you're in the house your kids grew up in and so forth, you might want to say my spouse can live here for the rest of my life, and then it goes to the kids or whatever. Sometimes there's a family farm. There's different things, but usually there's some provision for the spouse and some provision possibly now for the kids, otherwise later. Some people, of course, keep their finances completely separated, and that's okay, but we still have to deal with things like the residences and the, your clothing and your personal items and things like that need to be addressed. So all of this is very good to spell out. A third thing you might want to think about is it might be a really good idea to appoint professional trustees or powers of attorney because they're neutral and nobody can blame them. Well, they could, but it's not as likely to be a problem that they're going to get blamed from favoring one side over another. So blended family is an ideal time to consider professionals. Secondly, if you're not using professionals, you might want to appoint, let's say, we have this for trustees, my son and my husband's son, co-trustees, so that they don't feel like one side is getting an advantage and in power and control over the other. That's if we can't serve. Otherwise, we're the trustee if we can serve. And the last thing I want you to think about, and I even bring this up with people who, who are married and have never been in a blended family. If you're doing an estate plan, what if one of you dies and the spouse gets remarried? Okay. Remember I talked about you want your hard-earned money to end up with your kids eventually, whatever's left, and you don't want it to be to that other guy's kids who you've never met yet. So this is important. There's provisions we can put in your will, your trust that say, for instance, we need to, if my surviving spouse is going to get remarried, that new spouse needs to sign a prenuptial agreement agreeing to the terms of this trust. Otherwise, my spouse won't get the benefit of the trust. That might be too complicated for me to explain right now, but what I'm saying is if you could have, for instance, half my estate is going in trust for my wife, and the other half is going in the family trust, which my wife can take money out of, but once she dies, it definitely goes to the kids. So often there can be two trusts in a situation like this, and you could say something like, the wife loses the family trust unless the spouse signs this. And that is all designed to make sure the money goes to your kids eventually, but your spouse is provided for. So the third thing is your healthcare directive, because I told you that the healthcare is, often an issue. So we just really want to pay special attention when we're working through that with you to make sure your wishes are in there clearly and the people are chosen wisely and good backups too, in case somebody can't do it. So those are some of the ways we address blended families in estate planning. And so I definitely, if you haven't had an estate plan updated or it wasn't really addressed the blended family issues, it would be good to look at. Or if you have an estate plan, you haven't talked to your attorney in 3 years, it'd be a really good idea to call and say, that's what we do. But sure, we'll sit down and talk to you and see if there's anything that needs to be updated. It's really important. So that's it for blended family considerations. Now taxes, which a couple of you said you were here for. And I have 3 sections here. While you're still alive, that's mostly income tax. And then gifting, which is both before and after you pass, and then after death. So while you are still alive, there's a few things that you might not be aware of. Long-term care costs are deductible on your taxes. So we often will see clients come in and, oh my gosh, we're paying for care. It could be in the house. It could be in a home, wherever it is. It's so expensive. And it is, right? I get it. But it is deductible on your taxes. And this is the important part. A lot of people don't want to touch their retirement accounts. They're like, I'll touch those last, And, but it's really smart. Let's say if I'm going to spend $50,000 on long-term care costs this year, I'm going to take $50,000 out of my IRA because they're going to offset each other, because it's going to be taxable income on the IRA and taxable or a tax deduction on the long-term care costs. A little more complicated than that, so you want to work with your tax preparer on the amount. But it's an opportunity to not pay taxes on that retirement fund that a lot of our clients miss out on. Well, they don't miss out on once we tell them and we're involved, but before we're involved. Okay, second, be strategic about capital gains. So people think there's one capital gains tax that's 15%, but there's really 3. It's 0, 15%, and 20%, depending on your income. So the 0% tax is if you're single and you're under 40,000 or married and under 80,000. So look at your income for the year. If you're getting to the end of the year and it's going to be under that, it would be great to sell your stock that's appreciated or any other capital gains because you'll pay 0 taxes. This is really important, especially because Governor Walz just proposed increasing the capital gains tax in Minnesota. This is federal tax I'm talking about, that's 0, 15, and 20%. The state tax, it's been taxed as ordinary income, and he's talking about raising it. So the timing capital gains is important. Third, be strategic about retirement savings. Again, if you have an income year that's not low, an income year that's kind of low, you might want to take extra funds out of retirement, your deferred accounts like your 401k and IRA, and move them into a Roth IRA. You'll be taxed on them that year, but in the future when you pull them out, you won't be taxed. So any year you have a lower income, or if you do, say, I don't know the tax brackets by heart, but let's say you have $60,000 in income, and the next tax bracket break is at $70,000. So you look at this with your CPA or tax preparer in December and say, well, I can take $10,000 out of my retirement account. I'm not going to be into a new higher tax bracket, so let me take advantage of that. So really every year, every December, you should look at this option. 4, bunching itemized deductions. Trump had a overhaul to the tax system a couple years ago, and itemized deductions are there's a higher level. It's harder to meet. More people do not have enough deductions to itemize. So what people do now that can work well is to bunch your deductions in 1 year, to have a lot in this year and a little bit next year. So the kind of deductions that you can manipulate are like tax payments. You can pay your taxes early. Gifts, you can coordinate how you're making gifts, and medical expenses. So those are another more things that you can do to maximize deductions in 1 year and then minimize them in the next. Next tax consideration is gifting. Seniors love to gift. I mean, I always say it's really important that you get good care, and that comes first. But it's nice to be able to gift. It's really a blessing and one of the joys of being a parent or having loved ones. So people think that you can't give more than $15,000 a year, and that is not true. There is no limit to what you can give. However, if you gift more than $15,000 a year to one person, you have to file a gift tax return. But there's usually no tax due unless you have a large estate, and then you should be working with your attorney and financial advisor on that. But for most people, you don't have to pay any tax, and neither does the recipient. And if you're married, let's say I'm married and my son's married, so I could give my son $15,000, I could give his wife $15,000, my husband can do the same. So you actually can give $60,000 to a married couple. A married couple can give $60,000 to a married couple without having to file the gift tax return. Second thing about gifting is you may want to wait to give appreciated assets until after death because they're not going to be taxable. For instance, if I gift my house in the will, instead of deeding it over to my son today, he's going to inherit a stepped-up basis. So I have the basis in the house based on when I bought it, but the market's gone up. When I die, he'll get the stepped-up basis. So nobody pays tax on that increase, even when he sells it. So I just had last year a man wanted to give this nice house in Montana to his son, and we were like, why don't you give him some cash? Because you're going to get the stepped-up basis on that house, and it's a big difference. And that's what he did. He actually passed away already, so that worked out well. Third, whenever you give to charity, if you do, I think that's just great. It's great to give from your retirement accounts because they're not going to pay tax on that money. No one will ever pay tax on it. You didn't, and they won't. And that's the only way to avoid taxes completely. So if you are charitably minded, this is a great way to gift in your estate plan and from year to year. So what you need to do, you don't take your RMD and put it in your checking account and write out a check. No, you have your financial company write out the check directly from your retirement account to like your church or the Red Cross or whoever and send it directly to them. And that is making the most of your money. So estate is the next consideration. After you die, you know they still are going to come after you after you die, so there's still tax concerns. So in Minnesota, there's an estate tax if your estate's over $3 million. Now, Governor Walz just proposed lowering it to 2.7. None of us will be surprised if the estate tax minimums are lowered because of COVID. I mean, how is this going to be paid for? And there's also more Democrats in power now, so it just tends to happen that the estate taxes go up and the limit goes down. The federal limit is 11 million. So if you're, even probably 2 million right now, and if your estate might increase, it's something to think about, and then that's the important part of an estate plan. Roughly in Minnesota, there's a graduated payment, but we say plan on paying 10% of any amount over 3 million. So it's definitely worth it to spend a little money on planning to avoid that if you're in that category. Secondly, and I alluded to this before, inheritances are not taxable. So normally, the only exception is deferred retirement accounts. Deferred is like IRAs and 401ks, not Roth IRAs, because you have not paid taxes yet on that money. So let's see, if my mom dies and leaves me her deferred retirement account, when I take the money out, I'll be taxed on it because no one was ever taxed on it. So that's the exception. But otherwise, generally, inheritances are not taxed. Okay. Then the third thing is that there are tax returns due after death. So we handle a lot of probates or just estate administrations that don't need a probate. And people are often surprised about this. So the tax returns that are often due are the personal income tax for the deceased person. And so I just had a couple of clients die in December. So they'll have tax returns due for 2019 or 2020, it was last year. And sometimes people say, well, she hasn't had enough income to file for a few years, but then it turns out the year she died for some reason, there is enough income to file. So we always check this as part of an estate administration. Does the decedent need to file a final income tax return? Okay, that's not the end of it though, because the estate or trust might have to file an income tax return. So if they receive interest or any kind of income over $600 per year, then a return has to be filed. So for example, the people that died in December of last year will file their income taxes now in 2021 for 2020, but the estate or trust taxes won't be filed till actually 2022 because it will, it'll take this year to wrap up those estates. So often taxes is what makes a probate last longer. It's because you just have to wait to get that final tax return in. And there's some fancy things we can do with shortening and adjusting the tax years. And so you want to work with somebody who's really experienced with estate returns. A CPA, or we do them also, they know how you can actually save money and get it done as quick as possible, but it is usually the longest thing. So that's why I say hire professionals to help protect your hard-earned money. It's really worth it. That's what we've found over and over again, and our clients have found too. This reasons why this is so complicated. It's it's the IRS and it's the tax code, and it's not simple. But there's benefits to working on it and maximizing the benefits for all those taxes you paid in all those years. So I hope this has been helpful and educational to you. I'm guessing all your questions are not answered. If you think that we can help you, with the things that I talked about, then we encourage you again that you can schedule a strategy session with Dawn, and she'll take time to understand what's going on and see if we can help. We'll be honest with you about if we can help or not. It's going to be confidential and complimentary again, and it can be done. There's a picture of Dawn. She's not on live this time. She was last time, but typically 30 minutes. You can do it over Zoom or the phone or in person if you want. And again, she listens to your concerns, explains how we can help, process and cost. And she's at personal attention, and we'll answer your questions. We want you to be educated and empowered. You can also schedule online at our website, safeharborstatelaw.com/schedule. You can just tell us at the end of this call if you're interested in scheduling. We did set aside times again for you guys because we know that when it's fresh in your mind, it's a lot. It's just a lot more workable for you. It's more helpful to you. So we'd love to do that. So just a reminder, we help clients in Minnesota and Wisconsin with estate planning, with probate, and with elder law. And I think this talk gave you, and that includes special needs, so I think this talk gave you an idea more about what's entailed in all of that. So as part of attending this, we are going to send you red flags for elder law help. And I have